Alain Heureux. I'm the president and the CEO of IB Europe, and IB Europe is a trade association for the digital advertising industry, and I'm based in Brussels. You will often hear from me that we need trade associations to structure and organize the industry. And why? The good example is this cookie e-privacy directive that happened in 2007. We were not ready, and in Brussels there was a telco directive that had to be revised. In that telco directive there was a paragraph dealing about technology that you use when you want to communicate with consumers. And in that there was a mention of cookies and IP addresses. Now guess what? They give that work to a member of the parliament and they say, can you revise that text? He went into discussion with consumer associations, with some business people, and tried to figure out how can we rule and regulate the usage of this cookie. Is it personal data, yes or no, and all kind of considerations. We were not ready as an association or as an industry. We didn't have IB Europe yet. And it went out to a kind of interpretation of the use of a cookie where in Brussels they say we need consent when you use a cookie. And then some people started to say, yeah, but what kind of consent? Explicit, prior, or just consent? Just these three words, if you are interpreting that in one way or another, it can take a total other outcome. Now, we suddenly woke up in 2008 and we went to the Commission and to the Parliament and we said like, hey, be careful because you're touching to the fuel of the industry. The fuel is the cookie. You're in the industry, and you know exactly what it means. If you touch on the cookie, you are deregulating all the engine of internet. And so we explained that, but maybe a little bit too late in Brussels in 2008. And we have said, be careful. Now then, the Commission said, okay, we will say to the countries that in fact what we want, it is more choice, more transparency and more control for the consumer when we are targeting them eventually, using things like cookies. They gave that sentence, consumer control, transparency and choice, with the text to the countries, because you have to know that in a legislative process a directive is still something that can be interpreted at local level. And people started to make an interpretation and a translation. And we have been fighting for 3 years to make sure that we had a harmonized answer in an ideal world where only the word consent was taken back, because then you can have consent in the browser setting, you can have consent in other kind of tools on the internet, but you protect the asset that is the cookie. And today I can say that not every country has yet transposed the directive, but 2 countries went in a very strict, what we call opt-in regime, the Netherlands and Croatia. What is, for me, a big catastrophe for these 2 countries, because it
for
means...
the industry.
For the local industry, for sure, because if you want to do a pan-European campaign now, you can still deal with your cookies all over the place, as 25 markets on the same way, and in 2 markets not on the same way. You will need to do an additional thing to get prior explicit consent from the consumer. We went back to the Commissioner Kroes and we said, look here, you are fighting to get a harmonized market in Europe. The first law that you implement creates disharmonization within Europe. She's a bit concerned about that, so she went back to Croatia and Netherlands and says like, we are not sure that the way you have made the interpretation is the right one. So we might still win back the case, but I wouldn't make a big catastrophe about the e-privacy directive, to come back to your question. What we all need to be careful about is the next big thing, and that is the revision of the data protection directive. It started last year, we were ready, we have now a lobby platform, we have now an organized industry in most of the markets, not yet in the Baltics, and with that we can start to lobby and to make sure that at national level and central level everybody understands the big challenge that we have to make a proper law, because I'm a lawyer and I think we need law. We need law to protect consumers, we need law to protect the industry, but let's make a good law. And that will be ready in 3 to 4 years. So we have 2, 3, 4 years to make sure that this big Bible of data protection that will be created will be a good one, where we can continue to do our job, consumer can continue to live with great products and services and relevant information, and that the regulator feels also like I've done a good job. But that's the big next challenge that we have all to work together.
So basically they think that cookie collects private data. And you as lawyer, can you explain just in simple words why it's not so?
We ask to the Commission now to revise in the Data Protection Directive the definition of personal data. Because personal data in direct marketing, typically, what was the original definition of personal data in direct marketing, it is your name, your address, your bank account, email, all kind of information that is well protected, because personal data in a contractual environment between you and me, you are a company, I'm a consumer.
That is not available in the cookies, right?
No, exactly. So now the question is, where do we put cookie? Anonymous data or personal data? We are trying to explain that it is more anonymous than personal. A cookie can become personal when you have, let's say, 10,000 cookies about me. You will start to profile me so good that it can only be me. And so it becomes very personal. But one cookie...
It's like a Google Analytics.
If you aggregate all the cookies from one person into one central pot, then I think you become close to the definition of personal data. But one cookie for one day, I think nobody can understand that it's Alain Heureux behind the cookie. And so we are trying to explain that, but it's not easy because it's new, it's technology. And it is not black and white. Sometimes, like I say, a cookie can be a personal data at a certain moment, but can also be totally anonymous. And that creates a difficulty, but that's interesting because we are creating the society, the digital society of tomorrow. And that's why we need to think far. We need to think in 10 to 15 years, this directive should still be working. And that's why I am saying, as a president of this industry and with other partners from other associations, dear Commissioner and Parliament people in Brussels, leave also some space for self-regulation, where the industry self-regulate itself, because in 10 years' time, you have a crystal ball, you know what will happen? No. But 5 years ago, I know that we had no Facebook and no Twitter. Imagine in 10 years' time what the industry will have. That's why self-regulation should have a role and regulation another one. Big challenge.
Thank you.
Thank you.